Is he right?
The Speaker of Parliament, recognizing that we have three co-equal arms of government, and the fact that the legislative function relative to the passage of a law does not terminate even when the bill is transmitted to the President, I think the posturing, the tone of the letter written by the Executive Secretary to the President, particularly the portion where it says cease and desist, is beyond it being contemptuous. One can even describe it as completely unlawful. Because you see, Parliament is in its lawful business of just transmitting the law to the President. In fact, you will recognize that under Article 106(7) of the Constitution uses the word presented, the transmission mechanism. It is when the bill so passed is transmitted to the President, he takes possession of it, he can then decide that I want to assent or not to. And the law specifically give the indication that when the President decides that I will not assent, what he should do. We are not being told that the President has taken possession or custody of the bill so passed and has come to the conclusion that on the basis of the pending suit, he's unable to assent. That is a different kettle of fish. At this point, we are still living in the mechanism, the process of just conveying the process to him. On what authority is Mr. Bedietuo Asante purporting to issue that letter? On what authority? On what statutory or constitutional basis is he putting up that letter? You see, it is becoming one too many. A process that I'll describe as sheer misconduct. If you recall, in this studio, you discussed this matter rigorously. The issue of Domelevo having to go. You recall that incident? It is the same Bedietuo who, purporting to act on the instructions of the President, asked the man to proceed on leave. For the first time in many years, the Supreme Court had the opportunity of describing the conduct of the President, again, conveyed by the same Asante Bedietuo, as unconstitutional. And in fact, if you read my Lord Justice Nene Amegache's judgment in the coalition of, this is how he described the President's conduct. In this case, the Presidency failed to consider that the Auditor General's office as the head of the audit service form part of the independent constitutional bodies. Hence, the Auditor General cannot be compelled to proceed on leave by any authority, especially where the effect of the directive was to interfere with the performance of his constitutional mandate. Today, our courts have found that our President, Nana Addo Dankwa Akufo-Addo, obviously acted unconstitutional in purporting to act Domelevo to proceed on leave. Now, is it not curious that where you have a president who is even a lawyer, one would expect a certain level of sobriety, a certain level of sober reflection, and taking decisions that have ultimate grand impact on how our governance structure. Look at the tone of the letter.
Cease and desist is English.
No, it is a threat. You hardly use that language. Any moment Samson Ladi uses that letter to somebody as instructed by your client, that person carries a certain level of consequence. It means that if you proceed, so it's actually a threatening letter. The tone, the language does not befit the office. And you see,
Parliament attempted, at least we now know, about 3 times to transmit this bill to the Presidency. When Parliament was aware that there has been a suit. There have been suits. At least there is one by Richard Sky. And that there is an injunction application pending. And part of the reliefs that are being sought is that they are seeking the court to prevent the Speaker from transmitting the bill to the President. It's one of the reliefs. Is Parliament not aware? So why did it go ahead to want to transmit it?
First of all, if you look at the reliefs that Amanda Odwe, is that the name?
Yeah, that's the 2023 suit.
Exactly.
We are talking about Richard Sky.
No, I'm coming. I'll deal with it too. You see, when Parliament is transmitting the bill so passed to the Presidency, Parliament is still in this legislative function. Mm-hmm. In fact, after the President is even done, assenting, the legislative function doesn't end, because the President would have to transmit the bill that he has assented back to Parliament. Then the clerk will now do the numbering. It is the clerk that will say it is now called Act 223, Act so.
And then proceed to gazette.
And then proceed the gazetting. So even when the President proposed to even assent, the legislative function doesn't end. There's still a chain. You understand? Now, when Amanda took the Speaker, among others, to the Supreme Court, the Supreme Court said, look, that legislative process is still in process. So we are unable, under the circumstance, to injunct the process. And to the mind of the court, a prima facie case has not been made. That is in the ruling delivered in July 2023. Now, Richard Sky, again, was seeking to stop Parliament from the transmitting. At that point, Parliament was just organizing its constitutional mandate. The Supreme Court has gloriously...
The time Amanda's injunction application was refused last year.
Yeah.
Was it June, July?
Yes, July. In fact, I made a point. July
Right.
2023.
Right. She was questioning the processes to pass it.
And
And the court said, we can't interfere until they are done.
Sure.
Okay? So you have come prematurely. Absolutely. The bill is done.
No, I am saying that.
In this instance, the bill is finished.
No, the legislative process has not ended. The legislative process has not ended. In fact, like I indicated earlier, when the President even assents, it must go back for the gazetting processes and all of those things are not done by the executive.
Did she have a specific relief to stop Parliament in transmitting the bill in the manner Richard Sky had? No.
No, Richard Sky was a bit more specific.
Correct.
Relative to the
So
process.
it says, don't transmit it.
Relative to the... But I'm saying that if you look at the overall conduct, unless, of course, the President has the liberty to decide which court process to respect and which one not to.
That's another argument.
No, but you see, the point ought to be made that I, Edudzi, was the counsel for the then minority leader, Haruna Idrisu, Samuel Okujeto Ablakwa, Mahama Ayariga, when we challenged the constitutionality of the e-levy law. At the time we were in the Supreme Court, right, the President was assenting to the law while the matter was pending at the Supreme Court. Unless, of course, we are saying that the President has the liberty to be hypocritical.
Okay.
Has the liberty to demonstrate a certain level of duplicity.
Right.
That cannot be the case.
It
is either respectfully that you respect that any time a matter comes to your attention, you must cease. And I give you a classic reference. During the NDC primaries, one of the candidates, the presidential candidate, one of the candidates took the whole process to court. Then the EC says, having been served with the process, they're unable to proceed. We said, okay, no problem. Through dialogue and others, the process was withdrawn. The EC came and conducted. Then, during September, the decision to do the limited registration, I issued a writ on behalf of the political parties. The EC was duly served with the process. They still went ahead. I am saying that. What democracy...
In fact, a couple of other citizens also issued.
Absolutely.
The EC went ahead. So we are not talking about the duplicitous conduct of officials in this direction.
Sure.
What I'm asking now is, from what you know, okay, the relief was that he should be stopped from transmitting it to the president. Should the speaker or should Parliament have attempted to transmit it in the first place?
I do not see any limit relative, at least for whatever is worth. The Richard Sky had the benefit of applying for contempt proceedings against Speaker or the clerk, that pending this matter, they have taken ABCD steps. As we speak, no such intervention from Richard Sky had happened. I am saying that that option is available. If you look at the ex parte Benjamin Dufour position of the Supreme Court, it may well be that any conduct that has the potential of undermining the administration of justice can be deemed contemptuous. But in this case, that conversation had not even come up. I am saying that the tone, the language of Nana Asante Bediatu, beyond it being blatantly, it's not grounded in law. I did not see the legal basis of that, what do you call it?
Okay.
And you see,
so I'm getting you to the specifics. So now flip it this way. The Speaker says, on the other hand, I have been served with a process that seeks to injunct me, the Speaker, from going ahead, or Parliament from going ahead. The Speaker is actually a party who has been sued, from going ahead with the approval process for the ministers who have been vetted. On that score, I will respect the court. I won't do anything. Was the Speaker wrong?
I won't say the Speaker is wrong. But you see, I like the fact that the Speaker puts himself in the mode of the President.
So if the Speaker is not wrong, is the President wrong?
You see, I have made a point about the cease and desist.
No, we have moved away from that.
No. You see, for me...
I want us to keep ourselves within... Let's keep ourselves within the suits.
No, the point is that the letter from the Presidency should be construed as a whole.
So we have dealt with the letter.
It's a full package.
No, sorry. So you have dealt with the letter. I want us to constrain ourselves to the context of the suits.
Very well.
If the Speaker was not wrong, as you say, and you believe that is the law, correct?
That should be the law.
The President was also not wrong, was he?
That
he's been served an injunction application. And it is as good as an injunction.
No. First of all, the Bediatu letter is not communicating the President's refusal to assent. That's a different matter.
It's communicating refusal to accept and to assent.
Good.
Because the reliefs include thou shalt not transmit.
Good.
So the one to accept says, you have been asked not to transmit.
No.
I will not accept.
No, don't. So that way.
And if I accept, I am supposed to assent or signify my refusal. The relief also says, thou shalt not assent.
No. First of all, the substantive relief relative to transmitter is not directed at the President. It's directed at the Speaker.
Correct.
And so, therefore, you cannot be telling the Speaker that don't transmit. If the relief says...
I'm being prevented from a wrong. I'm being prevented from a wrong. You are saying that you should countenance the wrong, knowing that I am being prevented from it.
No. If there was a substantive relief,
saying,
Mr. President, do not accept the transmitter of this letter to you, then you can say, there is a relief preventing me from conducting myself in a particular way. There was no such in Richard Sky's process. So the President cannot use that as a rule to prevent Parliament from conducting its constitutional responsibility. If the process had gotten to him and the President is minded not to assent, then the President can say, having become aware of this, I am unable to put my signature below it.
So you hold on. Yes.